gentlemen, it's time to call the next case, that being the state of Ohio versus Taylor, August Taylor. We have a full panel of jurors ready to hear this matter. The jurors would please rise with me as they're able and raise their right hands. Do you swear or affirm that you will diligently inquire into and carefully deliberate all matters in the state of Ohio and August Taylor to the best of your skill and understanding, without bias or prejudice, and subject to the penalties of perjury? If so, say I do. Let the record reflect that all jurors have indicated the affirmative. Please be seated. Please be comfortable. Would counsel for the state please introduce themselves to the jury and enter their names for the record.
Good morning, my name is Ellen. My name is Autumn Edwards.
Thank you.
Good morning, my name is Renee Gooch.
Thank you.
Good morning, my name is Michaela Linfield.
Thank you.
Good morning, my name is Natalie Nelson.
Thank you. Would counsel for the defendant please enter their appearances for the record and introduce themselves to the jury.
Good morning, my name is Max Hickey. Good morning, my name is Nicholas Jacobs.
Good morning, my name is Sarah.
Very good. Thank you, ladies and gentlemen. Now, let me encourage you, as you see, we're being live streamed today. You do have microphones at your tables. Please speak very loudly for me. I am getting older, and it is harder for me to hear. So I have a very loud voice. I'm going to invite you to approximate that volume as you proceed today. Is the state of Ohio prepared to proceed at this time?
Yes, sir.
Okay. Opening statements by the state of Ohio. Please proceed.
Good morning, jurors. My name is Ellen Kirk, and I am here today with my co-counsel, Autumn Eccles. We represent the state of Ohio in today's case. We are here because of a young lady named Jordan Settles. This woman, of just 18 years old, was injured at the hands of August Taylor. August punched this young woman over and over and over while she laid in the fetal position. She was badly injured with a sprained ankle, bruises, and concussions. Our job today is to prove beyond a reasonable doubt that August Taylor committed these crimes against Ms. Settles. Throughout the course of this trial, you will see our prosecution team meet the standard of proof. We're going to bring in a lot of different people. They'll come before you, sit right here, and tell you what they saw, heard, investigated, and reviewed. These people will tell you the events as they witnessed them. You're going to hear from the victim, Jordan Settles, whose life has been thrown upside down since that dreary February day when my client was only trying to enjoy a friendly high school basketball game. Whilst waiting in line at the concession stand, August Taylor assaulted Ms. Settles. You will have Officer Dominique Dallas on the witness stand, describing the horrible acts he bore witness to while on the job. You will have Emery Easton, an innocent bystander who got caught up in the mischief that Ms. Taylor caused. We will prove beyond a reasonable doubt that the defense, August Taylor, initiated contact with Jordan Settles, and after a verbal argument was exchanged, August beat up Jordan Settles. Although the use of physicality is never the best option, my client, Jordan Settles, initiated contact in order to defuse the situation and get past August to end this interaction. His physical touch was only minor to defuse the situation and get past August. He was met with much aggression. You will learn that August pushed Jordan numerous times, causing him to fall and twist his ankle. You will learn that he was punched, causing his concussion, and while he was laid on the ground defenseless, August kicked the victim in the head. We will prove beyond a reasonable doubt that August Taylor knowingly assaulted Jordan Settles and caused him harm. After considering the evidence brought forth to you, we will ask that you, the jury, return the only verdict supported by the evidence, that August Taylor is guilty of felonious assault of the second degree.
Thank you. Opening statement of the defendant, please. Thank you, Your Honor.
Your Honor, and ladies and gentlemen of the jury, we are here today purely because an innocent high schooler was bullied relentlessly throughout the school year and finally responded to his bully's violent actions in a similar manner. August Taylor will testify to her experiences at Franklin High School and how he responded to her treatment from his peers. On behalf of August, her family, and on behalf of the future of Franklin High School's learning environment for its students, I ask that you find August not guilty on all counts. We will create a reasonable doubt that August was acting in self-defense in response to Ms. Settle's violent actions toward my client at that basketball game in February of 2024. Nothing that August Taylor did that night was an unreasonable response to the abuse she endured throughout the school year, which ultimately led to him changing schools due to the constant tormenting and bullying she experienced from Jordan Settle's relentless barrage of insults and offensive statements regarding my client. When Jordan violated her CPO by posting threatening images online, August did not respond in any way, shape, or form. At the basketball game, when Jordan saw my client, she began screaming at my client. My client responded in the only way that could end my client's suffering and neutralize the threat posed by this bully.
Thank you. Is the state of Ohio ready to call its first witness, please?
Yes, Your Honor.
All right, please do so. Who will you be calling?
Officer Dominique Dallas.
Very good. Would Officer Dominic Dallas please come forward? You'll see a ramp. Please walk to the top of the ramp, pause, and raise your right hand. I'll come to the top if you wish. Raise your right hand. Do you solemnly swear or affirm the testimony you're about to begin in this matter shall be the truth, the whole truth, and nothing but the truth, as to all subject matters contained therein?
I do.
Please be seated. Please be comfortable. Please make sure you keep your voice up. Your witness.
Hello, could you please state your name?
Dominique Dallas.
Where do you work?
I work at the Franklin Police Department. I'm the patrol officer.
Your position and your job title?
I'm the patrol officer.
What types of cases or calls do you currently work with?
The calls I receive are about students with conflict.
Where are you currently assigned?
I am assigned to Easterville and Franklin High.
Are you familiar with the attending students?
I know most of the students from both schools I work at.
How would you describe the behavior of the attending students?
They are all normally great and well behaved.
I'd like to direct your attention to February 2024, the day of the altercation. Do you remember this day?
Yes.
What do you remember?
I remember a fight between two students at the concession stand at a basketball game between Easterville and Franklin High.
How did you become involved in the altercation?
I received a call on my walkie-talkie.
And what did the call state?
One of the students was really aggressive and beating the other student, who was pretty helpless.
At the scene, what did you observe?
I saw one student on the ground and the other student, and the aggressor kicking that student in the head.
Do you believe these actions were intentional and meant to cause harm?
Yes, I did.
What happened after the altercation?
I separated the two students and arrested the aggressor and charged him with felonious assault.
What led you to charging felonious assault?
Jordan, how could I not? The victim was laying on the ground defenseless, and the aggressor was kicking him in the head. It's my job to protect the society.
Thank you. No further questions.
Thank you. The witness can stay in the seat, please. We'll have cross-examination, I believe. Am I correct about that?
So,
Very good. If the defendant would, defense counsel would offer cross-examination at this time, please. You are welcome to use the podium, or you're welcome to approach within a reasonable distance, but not too close to the stand.
what is your name?
I am Dominic Dallas.
What is your profession?
I am a police officer for the Franklin Police Department.
And what did you witness on the basketball game of February 2024?
I witnessed two students at the concession stand. One student was laying on the ground defenseless, and another was kicking him or beating him in the head.
What was your response to these events?
I separated them up, and I arrested the aggressor.
Jordan initiated the contact, correct?
No, incorrect.
Objection, Your Honor. It's a contradicting statement.
Well, it's pretty atypical for the defense to object to the questioning of their own client, but overruled.
Did Jordan seem to be scared as he attacked August?
Yes, he was really frightened.
No further questions?
No further questions.
Very good. It's the court's understanding that pursuant to the rules applicable in this matter, there will not be any redirect or rebuttal session. This witness can stand down. Thank you. Is the state ready to call its next witness?
Yes.
Please do so. Will this baby call, please?
Elizabeth Carl Aveni Easton.
Very good. Emery Easton, please come forward. You'll see a ramp here. If you come to the top of the ramp and pause there for me and raise your right hand. Raise your right hand for me. Do you solemnly swear or affirm the testimony you're about to give in this matter should be the truth, the whole truth, and nothing but the truth as to the subject matters contained therein?
Yes, sir.
Please be seated. Please be comfortable. Please make sure you keep your voice up. You're a witness.
Could you please state your name,
Yes, Emery Easton,
your age,
18,
and what school do you attend?
FHS, Franklin High School.
What is your relationship to Jordan Settles?
We are best friends.
When did you meet Jordan?
5th grade.
How would you describe her?
She's really cool, but at the senior year, she's been so awesome. Like, for example, she was very nice, and in the beginning of the year, she tried to befriend some of the incoming junior seniors, including August. Also, she had gotten into a little trouble in the past, but this year she's done a great job at staying out of trouble. Well, of course, it's Liz.
Could you describe the physical appearance and size of Jordan?
Jordan is pretty small.
Could you describe the appearance and size of August?
August is taller and bigger.
Would you say that there is a significant difference in size between the two?
Yes, Jordan often has to look up to August when talking to her.
Now I'd like to direct your attention to February 2024 on the date of the altercation. Do you remember this date?
Not exactly.
What do you remember from this day?
Going to the FHS game with Jordan.
And what brought you to the game and what activities took place?
Well, Jordan and I wanted to be more involved in our school for senior year, so we thought going to the game would be a good way of doing that. However, during halftime, Jordan and I got hungry, so we decided to go to concessions.
While at concessions, who did you observe, who initiated the exchange between August and Jordan?
While in line, August, who initiated the conversation, screamed at Jordan and stated, "Bro, what are you doing here?"
And what occurred after the exchange?
Jordan and I walked around August so that we could move up in the line.
Was the area crowded?
Yes.
And what was August's reaction to you walking past?
August seemed pretty aggravated and started beating Jordan to the ground.
Do you believe August knowingly assaulted Jordan with the intention of harm?
Yes, of course.
Do you believe these actions to be excessive given the accidental rush due to the crowded area?
Yes.
What did you do after the altercation?
Well, it's pretty helpless watching my best friend be beaten to the ground, and while she was trying to walk away, but she couldn't, she was kicked in the head. So I called 911.
That's all, no further questions.
Very good. Thank you. Cross-examination by the defense.
Thank you, Your Honor. What is your name?
Jordan, sorry. Emery Easton, 18.
What did you see the night of the Easterville festival?
Well, mostly the game, and August beating Jordan to the ground.
Did you realize that Jordan had been bullying August for most of the school year?
No.
Counsel, I'm going to ask you to keep your voice just up high, a little higher for me.
Did Jordan attack August first?
No.
Was Jordan threatening August when he attacked her?
No.
Can you give us a recap of the events that happened on that night?
Yes. So Jordan and I wanted to attend a game because we thought it would be a good way to be more involved in our school for senior year. During halftime, Jordan and I became hungry, so we went to the concession stand. When out of nowhere, August screamed and stated, "Bro, what are you doing here?" Jordan stated and replied, "You're so stupid." So, Jordan and I tried to walk around August. It was very crowded, so I couldn't tell from where I was seeing, but Jordan might have accidentally brushed August, but not like a bush. And Jordan and I walked around, moved up in the line,
When August out of nowhere started beating Jordan to the ground and kicked her in the head.
No further questions. Very good. This witness can stand down. Thank you. Does the state of Ohio have any further witnesses to call on this matter?
Yes, Your Honor, Jordan Settles.
Okay, the court would have Jordan Settles come forward. You see a ramp. Come to the top of the ramp and pause there for me and raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter should be the truth, the whole truth, and nothing but the truth, subject to penalties of perjury contained therein? Please. Okay, please be seated. Please keep your voice up. Please be comfortable.
Hello, how are you doing today?
I'm doing okay.
That's good.
What is your name? My name is Jordan Settles.
Where were you the night of the Franklin versus Easterville game?
I was in attendance.
Why were you here?
Well, I have a lot of friends, and it's senior night, so I went to go to have fun.
Did you see August Taylor?
When I was in the concession line.
Did you think August would be there?
No, he didn't go to either school, and wasn't friends with anyone. I never thought we'd be there.
When did you first see August Taylor?
When I was in line with my friends for concessions.
Who first initiated verbal contact?
August Taylor.
What did he say?
Bro, what are you doing here?
Did you touch August Taylor?
Yes, but it was not part of the school.
Was the area you were in crowded?
Yes, it's a concession stand.
Were there a lot of people?
There were tons. It was insane.
Was it an attempt to get past him and away from the situations?
Yes.
What did August do after you lightly touched him?
He punched me many times.
Did you fall?
Yes, it hurt so bad.
What happened after you fell?
He kicked me in the head, and I was already on the ground.
Did you hit him?
No, I would never hit someone.
Did you kick him?
No,
Did you punch August?
of course not.
No further questions, Your Honor.
Very good. Cross-examination.
What's your name and age?
My name is Jordan Settles, and I'm 18 years old.
Were you in contact with August throughout the school year?
Yes.
When did you first meet August?
It was on the first night of orientation, and we became friends at that night.
Were you sending messages to August that could be perceived as bullying throughout the school year?
Yes, but it's very jokeful. I usually joke around with my face.
Would you consider what you said to August throughout the school year to be a joke?
Yes, I usually joke around with my friends, and she usually takes it as a joke.
At the basketball game, you initiated contact, correct?
No.
From what I understand, you were the first person to touch August, correct?
No, I actually was in the concession line, and August was in my way, so I decided to walk past him, but she decided to think that I was pushing her.
So you did touch August before August touched you.
Yes.
Okay, are you aware that August suffers from mental disorders such as PTSD as a direct cause from the bullying that she endured throughout the year from you?
Objection, Your Honor, relevant. That information is only applicable in a civil case. It provides no relevance to this case.
Overruled. It does have material bearing. Thank you. Please continue.
Yes.
No further questions.
Very good. Thank you. This witness can stand down. Am I correct in understanding that the state of Ohio has no further witnesses to call on this matter?
Yes, Your Honor.
Okay, very good. Does the state of Ohio rest its case subject to the admission of exhibits?
Yes, Your Honor.
Very good. I don't believe any exhibits have been used in this case. Is that correct? Okay, very good. Ladies and gentlemen of the jury, a reminder, the defense may at this time present evidence of their own, but they are not required to present evidence under the instructions that I would have previously given to you at the beginning of this trial, which is to say the defendants are entitled to a constitutional presumption of innocence up until the moment that you determine otherwise, and the defense has no obligation or burden whatsoever to prove or establish anything. Would the defense care to put on a case at this time?
Yes, Your Honor.
All right, please do so. Are you going to call your first witness?
Yes, Your Honor.
Who would you call?
The defense called August Taylor to the stand.
Very good. Court recognizes August Taylor to the stand. August Taylor, if you would come forward. You'll see a ramp here in this corner. Come to the top of the ramp, pause there for me, and raise your right hand. Would you raise your right hand for me? Do you solemnly swear or affirm the testimony you're about to give in this matter should be the truth, the whole truth, and nothing but the truth as to the subject matters contained therein? Okay, please be seated. Please be comfortable. Please make sure you keep your voice nice and loud for us. Your witness.
Please state your name and age for the record.
August Taylor, I'm 18 years old.
Where did you begin your senior year of high school?
Fairfield High School.
Did you meet anyone in specific at the beginning of the school year?
Yes. Jordan says.
When did George first start tormenting you?
When did what?
When did Jordan first start bullying you? What was the reason that you gave your counselor when you met with them for missing school?
The first day of school, Jordan immediately started assaulting us, and he called me very physically.
So we're going to have a little bit of trouble hearing you. I'm going to ask you, there's a microphone that's right there at your elbow. You could speak a little louder until that happens. Thank you. Your next question, counsel.
All right, please describe to us what happened at the basketball game in February.
Jordan has a sexual problem in the school, which is New York and Instagram question.
All right, do you have any diagnosed mental disorders that could have affected your actions that night?
No.
Are you sure?
Yeah.
No further questions, Your Honor.
Very good. Thank you. Cross-examination. No, this witness will stay here. You're going to be cross-examined about the state of Ohio.
Could you state your name again, please? Where do you go to school? Okay. Currently? You currently go to Franklin High School. Are you sure?
Well, I think that there's a stipulation in the fact that...
There's a stipulation that you go to Old Bank Academy.
Court will recognize...
There's also a stipulation that she has PTSD.
Very good. The court will recognize the stipulations that are within the fact pattern presented before the court. Please proceed.
On what date did you meet Jordan Settles? On what date did you meet Jordan Settles?
Ms. Taylor, if I may, let me offer you your witness statement that was previously admitted as part of the record of this court. That may help.
Thank you, Your Honor.
Your next question, counsel.
At the night of the basketball game, if you knew that Jordan was a very social person and went to a lot of events and such, you agree that you went to neither high school that was at the basketball game, and why would you go to the basketball game knowing that Jordan would likely be there?
I know you do.
Do you agree that Jordan is a very social person, has a lot of friends, like it said in your statement? Okay. So, would you agree that a social person would likely go to a school event?
Yes.
So do you think it's safe to assume that there was a good chance Jordan Settles would be at the basketball game? So you don't think he would have been at the basketball game even though it was a big event and he's a very social person, it was a big social event? Okay. If you were supposedly afraid of August, why did you speak to him first and initiate contact?
Objection, Your Honor.
Basis.
The witness on the stand is August Taylor.
Sustained. Why don't you rephrase the question?
Thank you. If you were afraid of Jordan, why did you initiate contact first?
Objection, Your Honor.
Basis?
In previous testimony, we heard that Jordan initiated contact.
I mean verbal contact, Your Honor.
Well, in any event, that would be a matter for the jury to determine the credibility and weight thereof. Please continue. The objection is overruled. Thank you.
Let me restate my question, please. If you were afraid of Jordan, why did you first initiate verbal contact? Did you initiate verbal contact with Jordan Settles? Excuse me? Yes? Okay. If you were afraid of Jordan, why did you initiate verbal contact?
Counsel, am I correct in understanding that your question is why the witness first spoke to Jordan Settles? Is that your question?
Yes, Your Honor.
Very good. The witness can answer that question, if the witness recalls.
So, you had said before in previous statements that you were afraid of Jordan Settles. I am asking, if you were afraid of her, why did you speak to her first? Do you agree that you spoke to her first? Okay, so why did you speak to her?
And did you understand the question? She's asking you why, if you were afraid of Jordan, you first spoke to Jordan when you could have just ignored her. That's effectively the question she's asking. Do you understand?
Your Honor, if I may, I don't think the witness recalls why she spoke to Jordan.
That's fair. Let's move on, counsel.
Thank you. Do you agree that Jordan Settles slightly pushed you? Okay. Do you agree that the concession area was very crowded as it was during a popular basketball game? Do you agree that there was a lot of people in the area? Do you think that it is easy to accidentally touch someone or brush up against someone when you are in a crowded area such as a concession stand? Okay. What did you do after Jordan slightly pushed you? You pushed him back? You hit him. Do you agree that you punched him? Do you agree that you punched him several times? What? No. Did you say no? One moment, please, Your Honor. Your Honor, it's in the stipulated facts.
Very good. Would you like to cross-examine the witness on those stipulated facts?
Yes, please.
Please go ahead and do so.
Did you punch Jordan Settles several times? So a moment ago you said no, so now you agree that yes, you did?
Your Honor, this is in the stipulated facts, so I don't think it matters what the witness says, since it's already been agreed on by both parties that she did indeed.
Well, this is open cross-examination,
The
counsel.
stipulated
Objections
facts
are
were
ruled.
written.
Please proceed.
So you agree that you punched him several times? Did Jordan punch you back? Why would you have chosen not to put that in your statement if Jordan did punch you back? Do you think that that information would have been relevant before? Do you think that if Jordan punched you back, the police officer would have seen it, considering that Dominique was in the area? Yes. Do you agree that the woman working the concession stand would have seen Jordan punch you back, considering that she was in the area? Yes. So do you understand where the trouble is here, that no one else in the area saw Jordan punch you, and you did not include it in your statement, but now you're saying that Jordan did punch you back? Do you still agree that Jordan punched you back? Yes. How many times did Jordan punch you? 3. How many? 3. 3 times? Why would you not put that in your claims and defenses? So, if Jordan punched you several times, why would you and your counsel not put that in your claims and defenses?
Very good, counsel. Let's move on to the next question, if you could, please.
Did Jordan fall to the ground after you punched him, after you punched her several times? No. So, it was agreed in the stipulated facts that Jordan fell to the ground. Did Jordan fall to the ground? No. So you agreed in the stipulated facts that Jordan fell to the ground. So do you no longer agree to that? Did you kick Jordan in the head? You agreed in the stipulated facts that you kicked Jordan in the head. Did he kick you back or initiate any other contact? What contact did he initiate? What? If the victim hit you in the head, why would you not mention that until now in court when you had a chance to put that in stipulated facts, in claims and defenses, and in your statements?
Very good. Any further questions, counsel?
No further questions.
Okay, very good. This witness can stand down. Thank you very much. Of course, understanding the defense has one further witness to call, is that correct?
Yes, Your Honor.
Please do so.
Let's call Jamie Justice to the stand.
Very good. If you would come forward, you'll see that there's a ramp here in this corner. If you walk to the top of the ramp and pause there for me and raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter to be the truth, the whole truth, and nothing but the truth, as the subject matters contained therein?
Yes.
Please be seated, please be comfortable, please make sure you keep your voice up. Your witness, thank you.
Could you please state your name for the record?
My name is Jamie Justice.
All right, why were you at that basketball game that night?
I'm a parent of a student.
What did you see on the night of the Easterville High School basketball game?
I saw a fight happening between two students.
Who started the fight that night?
A student named Jordan Stubbs.
Who made the first physical contact?
Basis?
Leading questions. The witness verified in her statement that she was not there for the entirety of it.
Well, that sounds like a good subject for cross-examination, but the objection is overruled. Please continue.
Who were the students that you saw fighting that night? What exactly did you hear when you were working the concession stand in that area?
I heard Jordan Stubbs saying, I heard Alice Taylor saying, what are you doing, bro? And Jordan Stubbs said, go away and age.
Now, I'm having a little bit of trouble here. If you could just shout at me a little bit more loudly. Okay, thank you very much. I know you have that big voice in there somewhere. Please proceed, counsel.
No further questions, Your Honor.
Oh, okay, very good. Cross-examination.
What is your name?
Jamie Justice.
Were you in attendance at the Franklin-Easterville basketball game in February 2024?
Yes.
Did you see August Taylor?
Yes.
Did you see Jordan Settles?
Yes.
Do you agree that August Taylor initiated verbal contact with Jordan Settles?
Yes.
Did you see Jordan lightly push August?
I saw more of a push.
So, in the stipulated facts, it states that both parties agreed that August Taylor only lightly, or that Jordan Settles only lightly pushed August Taylor. Do you think that the event and perhaps the chaos of the night of the event could have caused you to have trouble in your remembrance of such due to heightened emotions?
No.
You don't agree that that could have caused you to perhaps forget some things or miss a detail here or there?
No.
So you stand by your statement that he pushed August Taylor hard,
Yes.
even though your party agreed that he pushed him only lightly? Okay. Are you aware that August and the council on your side agreed in the stipulated facts that Jordan only pushed him lightly?
Objection, Your Honor, asked and answered.
Sustained.
Did you see August Taylor punch Jordan Settles?
Yes.
Did you see him push him multiple times?
Yes.
Did you see Jordan Settles fall to the ground?
Yes.
Did you see August Taylor kick him in the head?
Yes.
Did you see Jordan Settles defend himself in any way whatsoever?
No.
Would you agree that Jordan Settles was helpless?
I would agree.
No further questions, Your Honor.
Very good. Thank you very much. This witness can stand down. Does the defense rest their case at this time?
Yes, Your Honor.
Very good. Ladies and gentlemen of the jury, this concludes the defense's presentation of evidence in this matter. We'll now proceed to closing arguments, which in the fuller instructions I would have given at the beginning of this testimony today would have established that closing arguments are not themselves evidence. You are not to consider them as evidence. They're just a way of thinking about the evidence that was previously presented to you. Think of them as a table of contents in a book. Is the state ready to present its closing arguments? Please do so.
Your Honor, and members of the jury, today we have examined the evidence regarding our client, Jordan Settles, a high school student who was physically assaulted due to addressing bullying with violence. Even though, I'm sorry.
Take your time.
Addressing bullying with violence is common in.
Down, counsel.
May I restart?
Please do.
Your Honor and members of the jury, today we have examined the evidence regarding our client, Jordan Settles, a high school student who was physically assaulted by August Taylor. Unfortunately, we live in a society where youth such as August decided to take matters into their own hands instead of navigating the situation through communication and respect. This is the decision of August Taylor, which led to harm and injuries from our client, lead us to this court today. August ultimately punched and kicked Jordan Settles with the intention of causing harm, giving Jordan Settles a concussion.
Thank you very much. Counsel for the defense, you prepared to offer your closing argument at this time?
Yes, Your Honor.
Please do so.
Ladies and gentlemen of the jury, I believe that my client August is innocent of felonious assault. He was an innocent high schooler who was bullied relentlessly throughout the school year. He was abused virtually, and at that night, borderline physically, by Jordan. And Jordan called my client August multiple names during August's time at Franklin High School. He made threatening and harassing social media posts pertaining to causing violence to my client August. And later, the night of the basketball game, he walked past my client, punching him, and my question to the jury is, where was the prosecution when this was happening? Where was the school when this was happening? When Jordan was bullying my client, my client felt alone, so much so that they had to make a protection order against Jordan Settles and later switch schools due to the countless harassment of Jordan. Members of the jury, August went to enjoy a basketball game. After buying some candy, she's confronted by Jordan, who she had a protective order against. After being shocked that Jordan was there, my client August yelled out, "What are you doing here, bro?" in shock. And Jordan replied back by screaming at August and initiated contact. Only then did August fight back. After skipping school, after switching school, and after getting a protective order, only then did August finally meet Jordan's aggression with violence. And Jordan shouldn't even have been there that night due to the protective order that had been set against her. Jordan should have walked away instead of further confronting my client and pushing him. I would like to ask you all today, if this was you or one of your kids, would you consider this a felonious assault or act of self-defense?
Thank you very much. Does the state have a rebuttal closing arguments?
Yes, Your Honor. And also, if I may clarify something, the defense counsel mentioned several things in regards to the high school administration who was a part of the civil case, not the criminal case. We ask that you and the jury reconsider those statements to give the victim the fair trial she deserves. So just speak for them.
Thank you very much. Ladies and gentlemen, as we've said previously, or would have said in a fuller explication of the trial, because the state of Ohio bears the burden of proof, they go first, then the defense goes second, and then they get a brief rebuttal closing arguments as well, because it is their burden to prove the elements of the case, each and every aspect, each and every element of the crime. So with that, we will hear the state's closing rebuttal argument. Please proceed.
Thank you. Your Honor and members of the jury, I wanted to clarify from the previous closing statement that the defendant did not have reasonable grounds to believe that he was in danger because he and Jordan had not been in contact for several months. Jordan had never initiated any physical contact until that light brush on the night of the basketball game in a very busy and crowded area. Due to this, the defendant did not have reasonable belief that he was in imminent danger or great bodily harm. This also led to him avoiding to retreat from danger when he had the opportunity to do so. This proves that it was not a case of self-defense, but mere an act of violence. Thank you.
Thank you very much. Ladies and gentlemen of the jury, this is the time when I will charge you with the law of the state of Ohio as it applies to this matter. You are to apply the law precisely as I give it to you. You are not to apply what you think the law should be. Does everyone understand that? Give me a good nod of the head to show me that you will faithfully discharge that responsibility. The law of the state of Ohio in this matter is as follows. Under Ohio Revised Code 2903.11, felonious assault, no person shall knowingly cause serious physical harm to another. There's also, to prove that the defendant's use of deadly force was not self-defense, it is the state's burden to prove beyond a reasonable doubt at least one of the following. One, the defendant was at fault in creating the situation, giving rise to his use of force. Or two, the defendant did not have reasonable grounds to believe that he was in imminent danger of death or great bodily harm. Or three, the defendant did not have an honest belief, even if mistaken, that he was in imminent danger of death or great bodily harm. Or four, the defendant violated a duty to retreat to avoid the danger. Or five, the defendant used unreasonable force. And a fuller explication of the law as it applied to this case in a normal trial in the state of Ohio, you would have a much fuller set of instructions that the court would read to you, and you would have a copy of it and you would read along with this. But that is the truncated version of the instructions on the law of felonious assaults and self-defense that you are to apply in this matter. And with that, I will discharge the jury to go and begin their deliberations. And that would be where we would stop. Ladies and gentlemen, so let me start off by saying it is a remarkable thing to have folks at this age doing as great a job as you all did in the course of this trial. Those are hard things to do, and every single one of you did a very fine job with the sort of artificial setting of this case. Let me ask the jury now, given the artificial nature of this, it may be entirely, let me put it this way. The least important thing is which side won or lost this trial. That is not where really the emphasis of this should be, because this is an entirely artificial thing. You would in real life have a much fuller set of instructions. Now, how many people would vote based on the evidence that they heard today to convict the defendant in this case? Raise your hand. About half. How many would vote to acquit or find not guilty the defendant in this case? Yeah. About a 50-50 split, a little bit of swing on one way or the other. In a real criminal case, the state of Ohio's burden of proving beyond a reasonable doubt all of the essential elements of the case is a very high burden, and we give that to criminal defendants as a constitutional right, because we would rather let the occasional person go free that was guilty than improperly convict an innocent person. So the deck is not a fair playing field. The deck is very much stacked in favor of the defendant. So it's a tough burden for the state of Ohio to prove all of the elements of a case in real life. One of the great things about being a judge is I never am supposed to tell the jury how I think I would vote, and I will hide behind that. But I will say that each of you did a great job on this. There are a couple of pointers that I would offer all of you before I let you get down to what I imagine is the briefing at the end of the day. The first thing is, on both sides, the story that you're telling the jury through your questions and then through your arguments is really the most important thing. If you don't need to repeat on cross-examination, as both sides did, sort of the basic facts that were already brought out in the direct testimony before you. You don't need to, if you know the person's name, the jury's heard the person's name, you don't need to spend the valuable time that you have on a cross-examination revisiting. What you might do instead is jump right into the story. If you're, for example, cross-examining Jordan Settles, the first thing that you would want to say is, you previously threatened Jordan Settles. You did it not just once, but you did it twice, didn't you? And isn't it true in your statement that at the time of this incident, right before the physical altercation, you threatened that you were going to punch him, or said that you could punch him, bro, didn't you? And then get them to say yes. And then you say, and so that would naturally put August Taylor in fear for his or her life, wouldn't it? And it doesn't really matter what the answer to that question is, because the jury will have heard it, and the jury will understand. So it is important that you get remember who you're representing, and then get your side of that story out as effectively as you can. A small practice pointer for the state of Ohio: Jordan Settles is not your client. Your client are the people of the state of Ohio, and your job is to see that justice is done. Your job is not to get a conviction. Your job is not to get an acquittal. Your job is to present the evidence to the jury for the jury to do their job, which is to determine whether the defendant is guilty or the state has not proven that the defendant is guilty. So you would call Jordan Settles the victim if the court would allow you to do that. I sometimes don't allow in a criminal trial the person who was injured to be called the victim. Sometimes I allow the alleged victim, or I use the person's name, because it is a little unfair to the defendant to have the jury constantly hearing from the very beginning of a trial that the injured person is the victim, because that's really a question for them to decide as a jury. So depending on the type of case and depending on the circumstances, sometimes I won't allow what you would think of as the victim to be called that. I might say alleged victim, or just simply address the person by their name. And that's, again, recognizing the very serious effect of a criminal trial on the person who's accused of a crime in the state of Ohio. Anybody have any questions about how it went, or anything that you'd like to ask the judge? Raise your hand if you have. My guess is you're all here because you're interested in the law. You're interested in the life experiences and the important stuff that happens in this courtroom. I will tell you that right now, the reason that I got here a little earlier, and it was because we're in the middle of a trial that's going to go for 2 weeks We just finished week 1 of the trial, and I had to come in here early to make sure that all of the stuff from that trial was pushed against that wall and not in the jury box and that kind of stuff, because there are important issues that are happening in that trial that I would not want, I would not want to be disrupted by what we're doing here today. Which is to say that important decisions and important things happen in this space, and you guys just got a little taste of what that's like. What do you think? Was it fun? Was it scary? Was it tough? Probably harder than you thought it would be, I guess, right? Well, I thought that both opening statements were really very good. I thought that sometimes it's hard when you have an artificial fact pattern. In real life, you wouldn't have stipulated facts like that. And so when you get new facts introduced that aren't part of the fact pattern, that obviously wouldn't happen quite as much in real life, but it does actually happen a little bit, where people say things slightly different in a real trial than what they did in the deposition or in the sworn statement before. And I thought the counsel actually did a very good job in using that to cross-examine when there were some variations in how it went. Let me tell you guys, it is no easy thing to get up in front of a room full of people, and particularly a room full of adults, and put on a case. And my compliments to everyone that was involved in that, because it wasn't an easy thing. Anything from the parents or the jurors or anyone else before I hand out some certificates? All right, folks, why don't we have the state and the state's witnesses come forward at this time, please? I have certificates of excellence and completion for each of you. Again, congratulations. Very good. If counsel for the defense and the witnesses for the defense would come forward. Thank you. Good job. Well done. All right, ladies and gentlemen, I think with that we are in recess. It's my understanding that you're all to go downstairs to, is it probably courtroom 2A that you're in? Yeah. All right, well, very good. If anyone would like to come and have a picture taken, there are parents with cameras. If you'd like to take pictures, this is kind of a neat little space, and I'll let anybody that would like to come forward take pictures to their heart's content.